Hi everyone and welcome to munshigiri.com. In this tutorial, we are going to talk about managerial remuneration. The various sections under which it is covered is section 196 to section 205 of Companies Act 2013, and the various rules under which it is covered is Companies Appointment and Remuneration of Managerial Personnel Rules 2014. So let's start with the definitions. So first definition we have is the definition of managing director, which is covered under section 2 clause 54 of Companies Act 2013. It says that managing director is a director who is entrusted with substantial powers of the management. Who is entrusted with substantial powers of the management. Now, the substantial powers of the management can be given by a director, can be given to a director by the articles of association, or it could be given by an agreement that the director has with the company, or by a resolution passed by the company at its general meeting, or it can be given by the board of directors to the managing director. So now another thing that we have here is managing director includes a director by whatever name he may be called. So there are certain situations that we are going to take here and we'll decide whether a person doing such tasks will be called as managing director or not. The first one is a director has the power to affix the common seal, or he has the power to draw and endorse check, or to draw and endorse any negotiable instrument. Now these powers are not included in the substantial powers of the management. So therefore, a director who is rendering these acts does not become the MD of the company. So here we draw certain inferences. The first one being that a person may be appointed as a MD, a person may be appointed as a managing director only and only if he is a director of the company. That is, a person who is not a director cannot be appointed as a managing director of the company. So all the provisions applicable to a director also apply to managing director, and if a managing director ceases to be director, he automatically ceases to be a managing director. Again, next thing is that a person who is not designated as managing director, but he occupies the position of managing director, he shall also be deemed to be a managing director. And next thing is, the managing director exercises his powers subject to superintendence, control and direction of board. The managing director is subordinate to the board of directors. That is, even though he has been provided with the substantial powers of the management, his powers and his authority can be revoked by the board of directors because he is subordinate to the board of directors. Now, two or more than two persons of a company may be entrusted with substantial powers of management. So we can say that a company can have two or more than two managing directors. However, a company cannot at the same time employ a managing director and a manager. A manager and a managing director cannot be employed simultaneously. There is a reason to this. We'll deal with that when we'll come to the definition of the manager. Now, managing director may be appointed as a rotational director or a non-rotational director. Coming to the another definition that we have in hand is manager. Manager is covered under section 2 clause 53 of Companies Act 2013. It says manager means an individual who has the management of whole or substantially the whole of the company, and includes a director or any other person occupying the position of a manager by whatever name called, and whether under a contract of service or not. Now, if we look at the two definitions that we covered over here, first one was the managing director. It said a director who has the substantial powers of the management. And coming to the definition of manager, it says an individual having substantial powers of management. If you note down that a managing director must be a director, but a manager need not be a director of the company. He can be any individual. That is what the definition says. That is, a manager is an individual who is having the substantial powers of the management. Okay, so manager need not be a director of the company. However, there is no restriction on appointment of a director as a manager. And a company can have only one manager. We covered that point earlier, that a manager and a managing director cannot be employed simultaneously in a company. So I hope you are clear as to why a managing director and manager cannot be employed simultaneously in a company, because both of them will be entrusted with substantially the whole of the powers of the management. So a company can either have a manager or a managing director. Coming to the another managerial personnel we have is whole-time director. Let's cover the definition of whole-time director. This definition is covered under section 2 clause 94 of Companies Act 2013. It says whole-time director includes a director in the whole-time employment of the company. Whole-time employment of the company. Now the question arises that whether a person can act as a whole-time director in more than one company. The answer is no. Simply a person cannot act as a whole-time director in more than one company. Whole-time director may be rotational or non-rotational. So these were the three definitions we had to cover under the managerial remuneration. Now coming to section 196. Which talks about the appointment of managerial personnel, that is the managing director, whole-time director or manager. Okay, so this is section 196. Section 196 of Companies Act 2013. First of all, this section applies to both the companies, that is the private company as well as the public company. It is applicable to both public and private company. Okay, starting with its sections. 196.1, it says, no company shall appoint or employ at the same time a manager and a managing director. So there is a clear prohibition on appointment of a managing director and manager simultaneously in a company. We have covered this point earlier also. Managing director and manager cannot be appointed simultaneously. Cannot be appointed simultaneously. (196)(2). It talks about the term of a managerial person. It says, no company shall appoint or reappoint any person as its managing director, whole-time director or manager for a term exceeding 5 years at a time. That is, a managerial person can be appointed in a stretch for a period of 5 years only, though he can be reappointed after he completes his term of 5 years, but one term cannot exceed 5 years. Further, no reappointment of managing director, whole-time director or manager shall be made not earlier than 1 year before the expiry of his term. So now if he is appointed for 5 years, so his reappointment cannot be made earlier than the 4th year. So like we cannot say that today we have appointed a director and today only we decide to reappoint the director for another term of 5 years. That is not, that case is not possible actually. So he can be reappointed not earlier than the 4th year in this case that we talked about. Next part in this section is, it talks about the various disqualifications for the appointment of managing director, disqualifications for the appointment of managerial personnel. Managerial personnel we are referring here to is MD, manager and whole-time director of the company. So we have 4 disqualifications here. The first one being a person who is below the age of 21 years, or who has attained the age of 70 years, that is 70 years or above. Further, it says that a person who has attained the age of 70 years may be appointed as managing director, whole-time director or manager if, now this person can be appointed if SR is passed, that is special resolution is passed, plus an explanatory statement is annexed to the notice. Explanatory statement annexed to the notice, which shall indicate the justification for appointing such person. This was the first disqualification. A person below 21 years or a person who has attained the age of 70 years cannot be appointed as managerial personnel, but a person of 70 years or above can be appointed provided special resolution is passed and explanatory statement is annexed to the notice, which justifies the appointment of a person above the age of 70 years. Coming to the second point that we have here is a person who is an undischarged insolvent. Undischarged insolvent, or who has at any time being adjudged as an insolvent, or at any time adjudged as an insolvent. This was the second disqualification. Coming to the third disqualification we have is a person who has at any time suspended payment to his creditors or has at any time made a composition with the creditors. Suspended payment to creditors, suspended payment, or made composition with creditors. Composition means that the creditor accepts the part of a debt in satisfaction from the debtor in a case of composition. Coming to the fourth and the last disqualification in this section we have is a person who has at any time been convicted by court of offence and sentenced for a period of more than 6 months. That is, convicted by court and this is and not or, sentenced for period more than 6 months. So any person on whom these disqualifications are not applicable can be appointed as a managing director, manager or whole-time director in a company. So this was about the disqualifications. Now coming to the approvals that are required for the appointment of managing director, whole-time director or manager. Coming to another part is approvals. All this is covered in section 196 only. So it says that the managerial personnel, that is the managing director, whole-time director or the manager, who shall appoint them? They shall be appointed by the board of directors. The terms and conditions of such appointment and remuneration shall be approved by the board of directors at a meeting, and this shall be subject to approval by resolution at the next general meeting. So, we can say that the managing director, whole-time director or manager are appointed by the board of directors, and then which shall be subject to approval. It has to be approved by the members in general meeting. Now next thing that comes is this approval. It shall also be subject to approval by central government in case the appointment is at variance to the conditions in Schedule 5. Now this Schedule 5 is applicable to managing director, whole-time director and manager. It has no applicability to ordinary director. So if the terms and conditions are at variance with Schedule 5, approval of central government is required. However, if the terms and conditions do not vary with Schedule 5, we do not require the approval of central government in that case. Now comes Rule 7. Rule 7 of Appointment and Remuneration of Managerial Personnel Rules 2014. Remuneration of Managerial Personnel Rules 2014. Now this rule states that it talks about the application basically. It says that the application for obtaining approval of central government should be made by company in Form MR2. Form MR2. And the application shall be made within 90 days of such appointment. So if the company has made an appointment of a managerial personnel today, so within 90 days of appointment, it has to apply to the central government for obtaining the approval, and such application has to be made in Form MR2. Now next thing that comes is notice for the board meeting or general meeting to contain certain disclosures. So the notice that we will be sending to the members for the approval, what all should be included in that notice, we're going to cover that now. So notice of both what? Notice of board meeting, or it could be notice of general meeting. It shall contain certain disclosures. The first one being the terms and conditions of the appointment of managerial personnel. First is the terms and conditions. Second is the remuneration that the company will be paying, the remuneration payable to such managerial personnel. And third is any other matters. Other matters could be including the interest of a director or directors in such appointment, if there is any. Okay. So now comes a case that the appointment is not approved in the general meeting. Appointment not approved in general meeting. So there could be this case, right? The board of directors appointed a person, then that was subject to approval by the members in general meeting. Now When the general meeting was conducted, the appointment was not approved in general meeting. What will happen in that case? Now, where the appointment of managing director, whole-time director or manager is not approved by the company at a general meeting, the acts done by such director before such approval shall not be deemed to be invalid. So, all acts done by such director they shall be valid if they are otherwise valid. So that was all about section 196 that talked about the appointments and other things, the approvals required, etc., the notice of board meeting. So now we are going to cover another section, that is section 197, which talks about the managerial remuneration. Coming to section 197, we have is overall managerial remuneration. This section says that the total managerial remuneration payable by a public company to its directors, managing director, whole-time director and its manager shall not exceed 11% of net profits for the financial year. Now, the difference between these two sections is 196 and 197 is that section 196 was applicable to private company as well as public company. Now here section 197 is applicable only in case of the public companies. It says that overall managerial remuneration not to exceed 11%. And to whom? To the directors, MD, whole-time director and manager. The total remuneration payable to these people should not exceed 11% of the net profits for financial year. And how will the net profits be calculated? In accordance with section 198, not 196. In accordance with section 198 of Companies Act 2013. So now the thing is whether a company can pay managerial remuneration exceeding 11%. Yes, that can be done. Now for that, the company in general meeting plus we need the approval of central government. The central government may authorize the remuneration exceeding 11% of net profits, and the provisions contained in Schedule 5 are complied with. Now comes the remuneration to managing director, whole-time director or manager. This was to all the directors, that is ordinary director, managing director, whole-time director and manager. It was 11%. Now we are talking about only the managing director, whole-time director or the manager. It says that remuneration to one managing director, we will say managerial personnel to these people, to one managerial personnel shall not exceed 5% of net profits of the company. Not exceeding 5% of net profits of the company. However, if there is more than one managerial personnel in a company, then the remuneration not to exceed 10%. Not to exceed 10% of net profits to all of them. This was a case when the company had only one managing director, whole-time director or manager. Now in case the company has more than one managing director, whole-time director or manager, the remuneration shall not exceed 10% of net profits to all of them. So now remuneration to directors other than managing director and whole-time director. We talked about these. Now directors other than MD, WTD and manager. Remuneration to these directors shall not exceed 1% of net profits. This is in a case when there is managing director, whole-time director or manager in the company. Now in case the company does not have MD or whole-time director or manager, in that case company can pay up to 3% of net profits to the directors other than managing director, whole-time director and manager. However, the company in general meeting may increase such remuneration. Now the question that comes here is whether the sitting fees payable to the directors is included in the remuneration or not. The section says that the percentage of remuneration specified above that we have done, it does not include sitting fees. Though sitting fees payable is the remuneration, but the above percentage shall be exclusive of any fees payable to directors. Sitting fees not included. Now, if the company has inadequate profits, what to do in that case? These are the cases we were covering when the company had adequate profits. Now, the company has inadequate profits or it does not have any profits. So, what do we do in that case? So, remuneration to, there can be two cases, like company has to pay remuneration to managing director, whole-time director and manager, and there can be ordinary directors. Ordinary directors are directors other than managing director, whole-time director or manager. So in this case, remuneration to managing director, whole-time director or manager, the company can pay remuneration either as per schedule 5 that we are going to cover later or with the approval of central government. With the approval of central government. For payment of remuneration to ordinary directors, we have to take the previous approval of central government. This was also previous approval of central government. Now this is how will the remuneration be determined? That is determination of remuneration. Now the remuneration payable to directors, managing or whole-time director or manager, it shall be determined by remuneration to be determined by, it can either be determined by the articles of the company, by articles or by resolution. Now if the articles state that the remuneration shall be determined by special resolution, then the special resolution shall determine. That is, the way the articles specify that this is the way the remuneration is to be determined, in that way we will determine the remuneration. So in other words, we can say that board of directors has no power to fix or determine the remuneration of directors, except with the concurrence of shareholders in general meeting or in accordance with articles of the company. So what it means is that if the articles say that the remuneration payable to the directors shall be determined by the board of directors, so in that case the board of directors shall determine it. So wasn't that simple? Coming to another thing that we have is remuneration determined shall be inclusive for the services rendered by him in other capacity, except the services of professional nature. So a director receiving remuneration is inclusive for services rendered by him. In any other capacity. except services of the professional nature. Remuneration for professional services can be separately determined and paid. In the opinion of Nomination and Remuneration Committee, the director possesses the necessary qualification for the practice of the profession. In case the company is not required to constitute the Nomination and Remuneration Committee, the Board of Directors, in the opinion of Board of Directors, the director possesses the necessary qualification. So we can say that for the services rendered in the professional capacity, a director can claim remuneration over and above the remuneration he is receiving as a managerial personnel in the company. Another thing is that over here is we are going to cover a case here which talks about whether the payment of guarantee commission forms part of remuneration. The answer is no. Let's discuss it why. So there was a case. The case was Susan Textile Bearings Limited versus Union of India. It was decided in that case that guarantee commission is payable to directors for the risk undertaken by them. For the risk undertaken for giving surety against loans or credit facilities taken by the company from financial institution. It is not paid for the services rendered in technical or manual or any other capacity. So it is a remuneration for any professional services. It is not a part of managerial remuneration. So it does not form part of managerial remuneration. Next is section 197(5). It talks about sitting fees. A director may receive the remuneration by way of fees for attending meetings of the board of directors or for attending the meetings of the committee. It says that the amount of fees, the sitting fees, shall not exceed 1 lakh rupees per meeting of board or committee. Another thing that this section says is that the sitting fees payable to women director and independent director shall not be less than the payable to the other directors. The women director and independent director shall receive same amount. That is, should not be less than this amount. Now till we have discussed about the managerial remuneration, now the question arises, how can the remuneration be paid by the company to its directors? That is, mode of payment of remuneration. Remuneration can be paid monthly, or it can be paid specified percentage of net profits, or partly by monthly, or partly by the specified percentage of net profits. If a director draws or receives remuneration in excess of the limit, what is in excess of the limit? 11% was the overall limit. Then we had 5% in case there is one managing director, whole-time director or manager. 10% if there is more than one. Remuneration to other directors other than managing director, whole-time director or director. This was 1% of net profits in case the company has managing director, whole-time director or manager, or it was 3% in case the company did not have did not have any managing director, manager or whole-time director. So now it says that if a director receives remuneration in excess of these limits, what will happen in that case? Now the director concerned shall refund the excess amount to the company. Refund the excess amount to the company. And until he refunds the excess amount, until he refunds such excess amount, he will hold this in trust. And the company cannot in any case waive the recovery of such remuneration. But there is one case, that is, the central government permits the company that the company shall not recover the excess remuneration paid to him. In that case, company can waive the recovery of the remuneration. Can this remuneration be increased? That is, increase in remuneration. Yes, it can be, but then how can it be increased? If there is a provision in the memorandum, or if there is a provision in the articles, or there is an agreement, or a resolution is passed in the general meeting. And also the board of directors can also increase the remuneration. But it shall be within the overall managerial remuneration. That is, these limits should be taken care of while increasing the remuneration. So we can say that any increase in remuneration shall not have any effect unless the increase is as per the conditions specified in Schedule 5 or with the approval of central government. Next is section, will look at it on other page. Okay. So alright. So we have a section 197.13. Whether the insurance premium paid by the company on behalf of keyman forms part of remuneration. The answer is yes, and the answer is also no. Okay, so insurance is taken by company on behalf of its managerial personnel, CEO, CFO or CS or whatever, for indemnifying any of them against any liability in respect of negligence, misfeasance, etc. So such insurance is not treated as part of remuneration. So I said it can be treated as part of remuneration, and then I had also said it cannot be treated as part of remuneration. So in general scenario, it cannot be treated as a part of remuneration. However, if such a person is proved guilty, against whom the company has taken the keyman insurance, then the premium paid on such insurance shall be treated as part of remuneration. So the first case was it was not treated as part of remuneration, nor it will be treated as a perquisite or income in the hands of the keyman personnel. However, if such person is found guilty or if is proved guilty, then the premium paid on such insurance policy shall be treated as part of remuneration to such person. Now we are done with this section. Coming to another section that we have is section 199. Now, can the remuneration paid to a director be recovered in any case? Section 199 deals with this case. It talks about the recovery of remuneration, and in which cases the company can recover the remuneration from its directors. It says that this section is attracted when a company is required to restate its financial statements. In case of restatement of financial statements. Now, when is the company required to restate its financial statement? It can be due to fraud, or it can be due to non-compliance with the requirements of this act or rules. Non-compliance with this act or the rules. Now, the company shall recover from any past or present MD, whole-time director, manager or CEO who received the remuneration in excess of what would have been payable as per the restatement of financial statements. So this was section 199. Another section that let's do the schedule 5 first, because that is more important. Okay, covering the schedule 5. Schedule 5 of Companies Act 2013. So the schedule 5 in all has 3 parts. Part 1, part 2 and part 3. So the first part 1, talks about the conditions to be fulfilled for appointment of managing director, whole-time director or manager without the approval of central government. Appointment of managerial personnel without approval of CG. Now it says if the following conditions are satisfied, a person can be appointed as a managerial personnel. There are basically 4 or 5 conditions. 6 conditions actually. The first one being not sentenced to imprisonment. For any period, or to a fine exceeding ₹1,000 for conviction of offence under certain acts. That is, not sentenced to imprisonment for any period or fine exceeding ₹1,000. Now there are certain acts. He is not convicted under certain acts. The various acts are Indian Stamp Act, Excise Act, Essential Commodities Act, Prevention of Food Adulteration Act, Companies Act 2013. Then we have SEBI, Securities Contracts Regulation Act, Sikh Industrial Companies Act, Competition Act, FEMA, Income Tax Act, Wealth Tax, Customs, Foreign Trade Development and Regulation Act, and the last one is Prevention of Money Laundering Act. So a person not sentenced to imprisonment for any period or for a fine exceeding ₹1,000 under the following acts that we covered right now. Second thing is that a person is not detained for any period under Conservation of Foreign Exchange and Prevention of Smuggling Act. First was not sentenced to imprisonment. Second is not detained for any period, the same, under Conservation of Foreign Exchange and Prevention of Smuggling Activities Act. If the central government has given its approval to the appointment of a person convicted or detained under the above acts, no further approval of CG shall be necessary for subsequent approval if he had not been so convicted or detained or subsequent to such approval. That is, if central government says that this person can be appointed as a managerial person, even though he has been detained under Conservation of Foreign Exchange and Prevention of Smuggling Activities Act, such person can be appointed as a managerial person in a company. Third is a person who has not completed 21 years of age but has attained 70 years of age. Now, where a person has attained the age of 70 years and his appointment is approved by the special resolution, no further approval of central government is necessary. We have done this case earlier also when we started this tutorial. That is the approval by special resolution. However, there is no exception in regard to the person who has not completed the age of 21 years. This is only in respect to a person who has attained the age of 70 years. These were three that we have covered. The fourth one is managerial person in more than one company. Now this managerial person can receive remuneration from both the companies, in the two companies in which he is holding his position as a managing director or anything. But the total remuneration received should not be more than the maximum remuneration admissible to the company. That is, the remuneration received from company 1 plus company 2 shall not exceed the limits. Fifth point is that he must be a resident of India. That the person must be a resident of India. Now, who is a resident of India? It says that the person who has been staying continuously for not less than 12 months immediately before the appointment. Staying not less than 12 months. Immediately before appointment. And who has come to India to stay. For what purpose? For taking up employment. For taking up employment in India, or for carrying a business or vocation in India. This was that the person must be resident in India, resident of India. Another point is, for a person who is proposed to be appointed in a special economic zone. Now, he can be a person resident outside India, but he should enter into India after obtaining proper employment visa from Indian mission abroad. Now, for that purpose, such person must submit the visa application with profile of the company, particulars of employer, and terms and conditions of appointment. So these were the this was the appointment of managerial person and the various conditions that we had to comply with without the approval of central government. Now comes part 2, that is the managerial remuneration, the most important part under schedule 5. We're done with part 1, now comes the part 2, which is managerial remuneration. Total sections under this part 2 we have is 5 sections. So there can be two things. One is that the company has profits, and another thing is that the company does not have profits. So the section 1 under this section deals with the companies having profits. It says that The remuneration payable should not exceed the limits specified under section 197. We have already seen section 197. It shall not exceed that. Next is section 2. This section deals with a company that has inadequate or it has absence of profits and it wants to pay the remuneration without the approval of central government. That is, inadequate case is inadequate profits plus payment of remuneration without approval of CG. Now it says there are certain limits given under this section, which says that where in a financial year a company has no profits or has inadequate profits, it may, without the approval of central government, pay remuneration to its managerial persons not exceeding the higher of the limits given under A and B. Now we have two cases. One, we'll take the higher of A and B. A is remuneration based on effective capital. Based on effective capital. And B is remuneration based on current relevant profits. So we'll cover this first, remuneration based on effective capital. Now it says where the effective capital of a company is, there are four cases. The first is the effective capital of the company is negative or less than 5 crore. Second is above 5 crore but below 100 crore. Above 100 crore but below 250 crores. And this is above 250 crores. 250 crores or above. So, now the yearly remuneration payable to each managerial person, payable to each MP, shall not to exceed 30 lakhs in the first case, 42 lakhs in this case, 60 lakhs in the third case, and where the effective capital is 250 crores or above, then in that case the yearly remuneration payable to each managerial person shall not exceed 60 lakhs plus 0.01% of effective capital in excess of rupees 250 crores. So this was A. Now it says that if the resolution passed by shareholders is special resolution, then the above limits shall be doubled. And there can be a case where the managerial personnel has been employed for a period less than 1 year. So it says yearly remuneration payable to each managerial personnel. In that case, that we will be the above limits, these limits we have talked about will be prorated. So coming to the B part of it, so we talked about higher of A and B. A we have already covered, in the B part we are going to cover now. It says remuneration based on current relevant profits. It says that the remuneration shall not be 2.5%, shall be 2.5% of the current relevant profits. 2.5% of current relevant profits. But this can be paid only in case of certain persons. Those certain persons are that is in case of a managerial person who was not security holder, holding the securities of a company of nominal value of 5 lakh rupees or more. Managerial person not holding securities of company of nominal value of rupees 5 lakhs or more, or employee or director or any person related to director or promoter at any time during the past 2 years prior to his employment as a managerial personnel. That is 2% of current relevant profits can be paid to a person who is not a managerial person holding securities of the company exceeding rupees 5 lakh or more, or who is not an employee or director of the company or is related to any director or promoter of the company during the past 2 years prior to his employment as a managerial person. In case there is a person falling in these two categories, we can pay the remuneration only as per the A that we have covered over here, that is remuneration based on the effective capital of the company. Okay, again, if the resolution is passed by shareholders, is special resolution, then this limit of 2.5% will be doubled, that is it will become then 5%. Okay, so the company can pay remuneration higher of these two, this one and this one, in case of inadequacy of profits. So there are certain conditions that are to be complied with in case the remuneration is paid by a company having inadequate profits. The first one being that the payment of remuneration should be approved by resolution passed by the board. That is, board resolution must be passed. And in case the company has a nomination and remuneration committee, it shall be approved by that committee. Second condition is that the company should not make default in repayment of any of its debts. In repayment of debts or debentures or interest payable for a continuous period of 30 days in the preceding financial year. And that is before the appointment of such managerial personnel. Third condition that we have is SR should be passed for payment of remuneration for a period not exceeding 3 years. Another is statement along with notice calling the general meeting is given to shareholders containing general information about the appointee, other information and certain disclosures to be made. That is statement with the notice. This has to be given to the shareholders. This will contain all the information and certain disclosures that are required to be made. This was section 2 that we were talking about. Coming to section 3. Section 3 is remuneration payable by companies having no profit or inadequate profit without CG approval in certain special circumstances. So in section 2 also we talked about the companies having the inadequate profits. No, we talked about both the things. In the first part we talked about companies having adequate profits, and in the second part we talked about companies having inadequate profits. This section deals only with the companies having inadequate profits, and such companies want to pay the remuneration to the managerial personnel without the approval of central government and in certain special circumstances. What are those special circumstances? The first one being that company is a foreign company. Company is a foreign company, or the company has got the approval of shareholders in general meeting to make such payment. Either it is a foreign company or approval of shareholders by SR in general meeting. However, the total managerial remuneration payable to its managerial person including such amount, is within the permissible limits of section 197. It cannot in any way exceed the limit specified under section 197. If it does, the company has to mandatorily take the permission of the central government in that case. Alright, this was first. Now comes the second. In case the company is a newly incorporated company. Newly incorporated company, and the remuneration is up to twice the amount permissible under section 2, and the remuneration is paid for 7 years from the date of incorporation, from incorporation of the company. The third one being the company is a sick company, and the scheme of revival or rehabilitation has been ordered by BIFR or NCLT. And how much remuneration then that the company can pay? Again, it is twice the amount permissible under section 2, and such remuneration is paid for a period of 5 years from the date of sanction of scheme of revival. We've covered 3 cases till now. The fourth one is that the company is in special economic zone, and this company has not raised money by way of public issue of shares or debentures in India, and no default has been made by company for a period of 30 days in repayment of any of its debt. Now this company can pay remuneration up to 240 lakhs per annum to its directors. So these were certain special circumstances that we covered. In these cases, the company can pay remuneration. Company can pay remuneration in case of no profits or inadequate profits without the approval of central government. Now comes section 4. So we talked about it that there are total of 5 sections. We've already covered 3 sections. Coming to section 4. This section says that perquisites are not to be included in the managerial remuneration. That is very obvious. Perquisites not to be included in managerial remuneration. So you all know that managerial person is eligible for a lot of perquisites. For example, the contribution to the provident fund. Like perquisites can be provident fund, superannuation fund, annuity fund, the gratuity payable that is not exceeding the half month salary for each completed year of service, or encashment of leave at the end. Right. So these perquisites are not going to be included in the managerial remuneration. These can be paid separately. Now an expatriate managerial person, including a non-resident Indian, he shall be eligible to certain things. The first one being the children education allowance, which will be maximum 12,000 per month, or actual expenses incurred. That is, we'll take the lower of these two, and this is admissible up to 2 children. Second is holiday passage. Holiday passages for children staying outside India or families staying abroad. Return holiday passage once in a year by economy class, or once in 2 years by first class. Third perquisite is LTC. Return passage for self and family in accordance with the rules specified by the company, where it is proposed that the leave be spent in the home country. Now we had covered the effective capital. So here we are going to talk about how to compute effective capital. We talked about effective capital in section 2. Now effective capital is computed as we'll add up certain items and we'll deduct certain items. First thing that we'll add up is aggregate of paid up share capital. Now this excludes the share application money or advances against the shares. Now amount standing to the credit of share premium account or securities premium account. Securities premium account. Long-term loans and deposits. Long-term means which are repayable after 1 year, and it excludes the working capital loans, overdrafts, interests due on loans, etc. And these are the items that we have to add. Now we'll deduct certain items. This paid up share capital is to be reduced by investments, accumulated losses, and preliminary expenses not written off. So if we'll add up these 6 items, we'll call it as effective capital. That is, we'll start with paid up share capital, we'll add securities premium, long-term loans and deposits, and we'll deduct investments, accumulated losses, and preliminary expenses not written off. This is how we'll come to effective capital. So what is the date of reckoning effective capital? If the appointment is made in the year in which the company is incorporated, effective capital shall be calculated on the date of appointment. In any other case, effective capital means it has to be taken on the last date of the financial year preceding the financial year in which the appointment of managerial personnel is made. So I hope you are clear with effective capital. Now till now we have covered 4 sections. Coming to the 5th section, that is section 5. It says remuneration payable to managerial personnel in 2 companies. Managerial personnel in 2 companies. It says that a managerial personnel shall draw remuneration from one or both the companies. Total remuneration drawn from the companies does not exceed the higher maximum limit of any one of the companies. That is, it has to be within the limit that we have talked about earlier. This was all about part 2 of managerial remuneration. Coming to the last part, part 3, which is nothing but that it only talks about the approval by the shareholders. It says that the appointment and remuneration referred to in part 1 and part 2 of schedule 5, it shall be subject to approval by a resolution of shareholders in the general meeting. That is part 1 plus part 2 remuneration. It is to be approved by shareholders. And the auditor or the secretary of the company, or where the company is not required to appoint a secretary, shall certify that the requirements of this schedule have been complied with. Such certificate shall be incorporated in the return filed with the registrar under section 196. So this was all about managerial remuneration. I hope you enjoyed today's session. Alright, I'll see you with another video. Thank you very much.